I'm going to speak to you about the role of human rights litigation in health law. And to do that, I'm going to take you to a variety of cases which have been decided by courts in a number of places. Those are the cases I'm going to talk through with you. Don't worry, it's not going to be too legalistic, and it's going to involve our going first to my homeland of South Africa. Then we'll go north to Kenya and Uganda. We'll have a short visit to India and then go to the United States, Brazil, and finally the European Court of Human Rights. So let's start off with just thinking about the right to health. It's a notion which has become commonplace in terms of discourse about human rights, but to term it as such is actually confusing. It's not really a term that's found in international human rights instruments. And it's much better and more accurate to refer to the right to the highest attainable standard of health. Here's the International Convention on Economic, Social, and Cultural Rights. That was a 1976 convention to which a great number of countries in the world, Australia included, are signatory. And tracking back in the modern era, without going back into the 50s, uh, you can see Article 12, which describes the right of everyone not to health or to being healthy, because those are truly unattainable aspirations, but to the enjoyment of the highest attainable standard of physical and mental health. And interestingly and significantly, you can see that there are subsets of that described within the article itself. I won't go through those, but you can see with A, B, and C issues to do with stillbirths, industrial hygiene, dealing with epidemics, and similar. It's the fourth of them, D, which is perhaps the important one, the creation of conditions which would assure to all medical service and medical attention in the event of sickness. So at the heart of this is making available services and medical attention required by people. Now, there's a general comment that's been generated in relation to the article, which just falls right into the problem that I've been articulating, because it starts off by saying that health is a fundamental human right, indispensable for exercise of other rights, which one can understand. But then it restates essentially the attainable standard of health language and refers to that as being conducive to living a life in dignity. So there's the comment. So let's see what else it says in that comment, because it starts to clarify the issue and take away the problems when one looks at the general issues within the comment. It says the right to health is not to be understood as the right to be healthy. It contains freedoms and entitlements. Freedoms involve the right to control one's health and body, and the right to be free from interference. By contrast, entitlements include the right to a system of health protection which provides quality of opportunity, it should be equality of opportunity for people to enjoy the highest attainable standard of health. So freedoms and entitlements. Now, to operationalize this, to make it meaningful across the globe, the general comment has identified indicia by reference to which states can satisfy their national obligations. And those, in short, relate to availability, accessibility, acceptability, and quality. So there have got to be facilities that people can find and get to. The facilities should be properly available to all. The facilities have to be of a decent standard, and the facilities also have to be culturally appropriate, ethical, and similar. So a combination of four factors which go to whether countries, which are known as states parties for this purpose, are satisfying what is required of them. The obligations for those states parties involve respecting the relevant things, including people's entitlements, protecting them, and fulfilling them by doing those things which are necessary legislatively, administratively, judicially and otherwise, in order for those rights to be meaningful in any given country. Now, I've given you that broad introduction to put in some kind of a hopefully coherent context what has happened in a series of landmark cases around the world, which I think are incredibly interesting and significant in a very practical sense. And I hope you'll find them so as well. The first is a decision in South Africa by the Constitutional Court. And the Constitutional Court has reserved to it just what you'd expect, key fundamental issues. Everyone will remember that in time past, South Africa had real reservations about treatment of HIV/AIDS and its obligation to its citizens and internationally to provide appropriate care and treatment, in spite of the availability of pharmacotherapies. A challenge was brought in 2002 by a variety of health associations and others concerned with the provision of care and treatment to people with HIV/AIDS. And it was in truly epidemic proportions in South Africa by reason of the inaccessibility and unavailability of medications which were available elsewhere in the world. The respondents were the National Minister for Health and executive councils for provision of health care in the various provinces of South Africa. South Africa had a program to address mother-to-child transmission of HIV, but it imposed restrictions on the availability of a key drug at that time, nevirapine. And that was just disastrous in terms of the increase in the incidence of HIV from HIV-positive mothers to their offspring. It was clear from initial evidence before the court that the drug would save lives. It didn't need to be administered with the full package. Just one administration would make a very significant difference. There were no particular risks from administration of the drug. The costs were of some consequence, and the plan was to administer the drug where there were testing and counselling facilities already. It was a genuinely possible innovation for South Africa. However, the governments resisted it. This was in face of a Bill of Rights in South Africa, the equivalent to what exists in the United States, which provided, amongst other things, that everybody had the right to have access to healthcare services, and South Africa had an obligation to take reasonable legislative and other measures to make sure that children had access to basic healthcare services. Of course, what was happening here was that children did not. So the court wrestled with the constitutional issues in it and the expert evidence before it, and they accepted, understandably, that given that the right involves giving what can reasonably be provided, that it's impossible to give everybody access to everything straight away. What is possible, though, the court said, and what can reasonably be expected of a state, is that it act reasonably to provide access to socioeconomic rights, including the right to the highest attainable standard of health on a progressive basis. So the court held that something did have to be done. The status quo was completely unacceptable. In short, it was unconstitutional because it was failing to provide for South Africa's obligations to children. They accepted that HIV/AIDS was the greatest threat to public health within South Africa, and the obligation of the state was to respect, protect, promote, and fulfill the right to health. And what they found was, in short, that the policy as it was existing at the time was failing to meet the constitutional requirements of South Africa for newborn children. And so the court made a series of declarations. First, that the Constitution was being breached, and in essence, that the state was obliged to provide progressive accessibility to the drug so that the transmission of HIV from mother to newborn would be substantially reduced. Now, you might say to yourselves, well, it's obvious. Of course, that's what the court should hold, and it's good that it did hold it. And that's a fair comment, but it took the decision of the case being placed before the Constitutional Court for this decision, which was truly a landmark one, especially for Africa. And the decision has had all manner of ripple effects, not just in South Africa, but elsewhere through the continent. I'll give you an example of that in a country in which I spent quite a bit of my youth as well, Kenya, where in 2012, so a little while after the South African decision, another case was placed before the High Court of Kenya. It occurred in an interesting context. The applicants involved in it were HIV/AIDS positive members of the community. And what they were worried about was that a new piece of legislation was likely to inhibit access to generic, affordable drugs, which would counteract HIV and preclude AIDS in most circumstances. And what the petitioners argued was that their rights to life, human dignity, and health were being breached by that. And the United Nations Special Rapporteur on Health intervened in the case, which underlines the significance of it. The decision was heard by a remarkable judge, Justice Ngugi, in Kenya. She emphasized the importance of the socioeconomic context of HIV/AIDS, the tragic situation within Kenya 12 years ago, of the scourge of the illness when it wasn't being effectively treated, with so many of those having HIV and then AIDS being unemployed, financially incapable of acquiring for themselves antiretroviral medications. And so what Her Honour held was that the state's obligation in relation to the right to health encompasses two things: a positive duty to make sure that citizens could have access to healthcare services and, most importantly, medication, and a negative duty not to do anything which would impede the positive duty. Now, what was happening here, of course, was that that extra legislation was intruding on access to the medication. Now, let me just say something about that. It was the Anti-Counterfeit Act. The legislation was intended to stop all manner of things coming into Kenya which were unlawful and which were breaching the customs regulations of the nation of Kenya. A perfectly laudable and sensible aspiration. The problem was that it was inhibiting the importation of generic antiretrovirals. So you had legislation which was doing something quite collateral, but was impacting upon people's access to drugs necessary to maintain health. Justice Ngugi looked at the nature of international trade, acknowledged the importance of enforcement of intellectual property. Then she looked at the issue of the right to life and dignity and health, and emphasized that those were not notions that were vague or insignificant. And ultimately, what she held was that there can be no room for ambiguity when something so important as the rights to health and life of people are at stake. And what she held was that the right to life, dignity, and health had to take priority over intellectual property rights of patent holders, which were being sought to be protected by the anti-counterfeiting legislation. So she said, it's fine legislation, but given the scourge of HIV, AIDS, the anti-counterfeit legislation cannot be allowed to inhibit access and importation of those medications. So again, it was a very important decision in terms of situating the right to the highest attainable standard of health where I think probably all of us would say it belongs, namely pretty much preeminent amongst the various kinds of issues and rights and legislation that exist within nation states. So let me take you next door to Uganda, where again the issue was the provision of minimum maternal health services. There was a provision in the Constitution guaranteeing the right to basic indispensable mental health services, suitable persons to provide them, and drugs which were pertinent to that kind of care. The petitioners in this case, this is only 4 years ago, relied on the fact that in Uganda, a significant number of women die in childbirth each year. And the deaths occurred in a variety of contexts around the delivery period, including in particular, as you would expect, postpartum sepsis. And what the court held was that the provision of health services depends largely on the availability of expert health resources. But the fact that those are limited, but they're very much finite in a country such as Uganda, cannot be used as an excuse or a defense for failure to provide basic services which will maintain life. The court reviewed a range of international instruments about the right to health and held that Uganda was obliged to make sure that it provided adequate equipment and supplies for preventive, diagnostic, and curative services. And that meant needing to train medical staff, developing suitable guidelines and protocols for the management of complications that were thoroughly foreseeable from the process of childbirth. And getting to the heart of the decision, it determined that the court could not under any circumstances, the state could not under any circumstances justify non-compliance with such core obligations. They noted that levels of maternal mortality were still very significant indeed. There'd been a roadmap which sounded good on paper, but it wasn't having a real impact on neonatal morbidity and mortality. It had been published in the order of a decade before, but reductions were not coming through in relation to either mortality or morbidity. They acknowledged that the government had made efforts to do positive things, but its failure to provide adequate basic maternal health care was not just a tragedy, but it was a breach of the government's fundamental obligation to provide health services to people who required them. They found that the right to life includes a constituent right to health. Now, believe it or not, this was groundbreaking because the right to health in international law has a considerable jurisprudence. And what the court postulated in this was that the right to health is essentially a subsidiary but fundamental component of the right to life. Now, whether that's going to be accepted ultimately by other major jurisdictions such as the European Court of Human Rights remains to be seen. But it's a very significant decision, especially in Africa, because it's pushed out thinking about where the right to health exists. And the right to life is generally regarded as the fundamental right that exists under every major international human rights instrument that you can think of. And so the court determined that amongst the various measures that a state party, such as Uganda, needs to apply, are measures that ensure access to healthcare. So that access word again, availability of health services, the second A word, and development of policies and measures to assist in access to those services which are directed toward reduction of maternal and infant mortality. They applied the PAO decision from Kenya and found multifarious breaches. They referred to the World Health Organization's recommendations, found that Uganda had not been satisfactorily applying those, and found that the limited budgetary allocation by the Ugandan government to this aspect of the health sector was in breach of its citizens' human rights. And it proclaimed preventable deaths of pregnant women at a government hospital deprives women of a right to enjoy and realize not only their right to life, but their sexual reproductive rights. And it pronounced that the government must provide proper services to have enough skilled attendants available 24 hours a day in order to provide care to women. So again, this was a very significant decision in which multiple breaches of rights of citizens were found in respect of access to this form of public health care. And it resulted in the issuing of a series of declarations finding the government at fault and failing to meet key aspects of its constitutional obligations to uphold the rights of women to life and also in respect of their reproductive rights. And it ordered the government to prioritise and provide sufficient funds in the budget for maternal health care. So again, you can see this was an articulation of some very significant principles and then a direct order to the government to change its budgetary allocations and provide that which was necessary in order to provide maternal health services that were sufficiently available and accessible and of suitable quality to those who required them. And not only that, in a very interesting aspect of the decision, the court directed the Minister for Health to provide a full audit report to the court within 2 years of its changes and what impact those changes were making to the lives of women. So quite an activist decision. You can see that trio of decisions starting in South Africa, then Kenya, then Uganda, are very significant internationally. Let's go east from Kenya and Uganda then to India. One of the most important decisions in relation to patents in the last 2 decades is the decision of the Supreme Court of India in Novartis and the Union of India. I won't dwell on this, but you'll appreciate very quickly the significance of this decision in terms of availability of medications. What occurred was that an application was made by Novartis, the Swiss pharmaceutical company, in relation to an anti-cancer drug for blood and intestinal cancer called Glivec. The drug was based on imatinib, one of the expensive mAbs. It was rejected on the basis that it wasn't a patentable invention because it was closely related to another drug. Now, what was actually going on behind the scenes here is that Novartis was trying to protect its patent rights internationally in relation to imatinib, and it was utilizing the legislation which was quite new in relation to patenting in India in the hope that it would get that protection and stop closely related products to the drug over which it already held patent rights. The Supreme Court of India would have nothing of it. They accepted that the new form of the drug was novel, but they found that it didn't meet the crucial yardstick of enhanced efficacy. Now, without getting technical about it, what it decided was that enhanced efficacy meant therapeutic efficacy. And although the new drug was a little bit different, and it might get to a relevant site to treat the cancer a bit quicker and better, it wasn't sufficiently different from the drug over which a patent had already been issued. And so the new drug was not a patentable invention. So it reasoned through these issues to do with bioavailability and found that there was not sufficient difference, in short, between the two versions of the drug. This has attracted a lot of international attention because India is a nation where a good deal of pharmaceutical innovation and development takes place. There was a lot of support internationally from advocacy groups, including the World Health Organization, for the stance taken by the Supreme Court of India against evergreening of pharmaceutical patents. There was a big difference between the patented version of Glivec and the generic versions which were becoming available and which were eroding the profit-taking of Novartis. And it's been argued by a number of commentators that a side effect of this decision would be to enhance innovation by pharmaceutical companies because they'd be propelled to invest more in research and development to develop new drugs rather than relying upon the drugs which had been developed some time ago and in respect of which they were deriving significant profits. So it's a fascinating and very significant decision in terms of accessibility and availability of medications, this time in relation to cancer. Let me make a brief reference now to a decision by the United States Supreme Court. And you'll see that this one's a little bit different. And it relates to the conditions in which people are housed in Californian prisons. Now, we think we've just been talking about some countries that some would term lower and middle income countries, and we customarily think of the United States as a developed and high income country. You wouldn't think that if you had a bit of a look at Californian prisons, which are very little better than those in Nairobi or Dar es Salaam. There's a Californian prison. Dangerous in all sorts of ways. You can imagine what happens with the prisoners attacking each other when there are different groups that don't like each other well. You can also imagine what happens when an illness of any kind gets into a prison where there's this level of congregate housing of prisoners. The Supreme Court, in a 5-4 decision, held that if a prison deprives inmates of adequate medical care, what it is doing is violating the obligation to refrain from cruel and unusual punishment, which is the Eighth Amendment in the US Constitution. And it held that it was that the prisons in California were depriving prisoners of proper medical care by inadequate facilities and by housing them in such overcrowded conditions. Now, again, you might say to yourselves, well, that's pretty obvious, but this is an extraordinary and fascinating decision in which a superior court intruded into the management of carceral residences and said, you have to change this because by housing prisoners in this way, you are breaching their rights to health, you are inflicting cruel and unusual punishment on them, you're breaching the Constitution, and on the basis of that, it ordered the prisons of a prison system to reduce the population to a mere 137.5% of design capacity within 2 years. I'm not quite sure what the levels were, but it was up somewhere around 200%. So what it was doing was contracting the number of prisoners being housed in a variety of the major penitentiaries in the United States. Now, the decision emphasized the rights to human dignity in prisoners as well as everybody else. It identified the unsanitary and unsafe conditions within prisons. It talked about suicidality, the problems with the inadequate segregation within US prisons. So it's a landmark decision in relation to health rights of prisoners with manifest application in many other parts of the world. The postscript to it isn't so happy. The state of California agreed to comply with the decision as they had to, given it was from the Supreme Court of the United States, not just California. And so they shuttled prisoners around. They didn't actually reduce populations in a significant degree. So the legacy of the decision is important in terms of principle and precedent. The outcome wasn't so constructive in terms of the individuals. So given that we've gone east from Africa to India to the United States. Let's go south now to Brazil, where there was a very significant decision and a courageous one in Brazil from a remarkable judge. And some of the judges involved in these are very fine people who have resisted intense pressures from government and from corporations. That's one of the things you can see in common. During COVID, there were all manner of problems throughout the world, but in Brazil, the numbers of persons contracting the virus escalated alarmingly. And one component of a population that became problematically infected in an overrepresented way was the indigenous population. This was starting to become highly embarrassing for the government. And so what they did was to change the way in which they were reporting for statistics. You might remember when Donald Trump talked about these things, he said, well, if you don't find the actual illnesses, then you don't so much have a problem, which was logically right, not very edifying, but it was technically right. So inspired by that kind of approach, the Ministry for Health in Brazil changed their daily reporting. They moved the reporting time to late in the evening. That resulted in less scrutiny. And they removed the online website, which showed the data that were coming through on a daily basis. And so you couldn't readily see any longer how COVID was spreading and where in particular it was spreading. Now, what happened was that the Sustainability Network, which was a group of different health activist organizations in Brazil, challenged the administrative decision-making of the ministry, contending that this was incompatible with Article 196 of the Brazil Constitution. That provision said that health is a right of all and the duty of the national government, and is guaranteed by social and economic policies aimed at reducing the risk of illness and other maladies, and equal access to services. So they said that by suppressing data about the incidence of the pandemic, the government was breaching the right to health. So it was a novel argument and a very interesting one, and it was all very politicized, as you can imagine. Well, it went before Justice Moraes in the Brazil High Court, who upheld the objection from a sustainability network, granted declarations in due course. He said that the disclosure of public health data is important to analysis of what's taking place during a pandemic and the planning of what's needed to assist public authorities in their decision-making processes. And the availability of data is also important, and more than important, necessary, to allow the general population to be fully aware of the pandemic situation that exists throughout the country. So he made a series of orders requiring the ministry to revert to proper disclosure of epidemiological data, stating otherwise irreparable damage might be caused by non-adherence to the constitutional principles of publicity and transparency, and with the constitutional duty to carry out actions of epidemiological and health surveillance in relation to life and health. It's a very interesting decision, I think, in terms of this time not so much availability of services, although that issue was lying behind it, but this time access to what's happening and how things are deteriorating or improving. So I'd classify it as a courageous stand in a country where courage can have adverse consequences for persons who exhibit it in terms of transparency of decision making and the capacity for the community to understand what is taking place in relation to public health. Let me take you on the last of our journeys then. This is a last journey to the east. So we've gone from west to east, and we now land in a decision originally arising from Spain and delivered just a few days ago by the Grand Chamber of the European Court of Human Rights. And the Grand Chamber is the appellate body of the European Court of Human Rights. It's a really interesting decision that articulates emphatically propositions with which we are reasonably comfortable and familiar from our own local decisions. But this stands as the most important international decision about the right to autonomy over one's own body and decision-making about provision of treatment to a person. Pindo Muller was a Spanish national, and she was being treated for urinary retention caused by a uterine fibroid. Importantly, she was a Jehovah's Witness, and she directed in a variety of ways that she not be given any blood transfusions. Not only did she do that, but she appointed 2 friends as personal representatives in the context of an advance directive, which again reiterated her moral position in relation to opposing blood transfusions. She was okay about having a hysterectomy and a double salpingectomy, and she authorized that, but part and parcel of that was no blood transfusion. Well, her conditions, before she was operated on, her conditions started to deteriorate, and she suffered severe bleeding. She started to have very serious anemia indeed. She was transported to hospital by an ambulance, and the clinical view was that her condition was dire. She was in a state of circulatory collapse from blood loss and at risk of immediate cardiac arrest. So the hospital, while she was in the ambulance, applied to the court in the relevant court in Madrid for authorization of treatment, and that involved transfusion, given the fact that she was in circulatory collapse. She was operated on as had been planned, and she was given a blood transfusion. She survived as a result of the interventions, so it was a clinical success, but it left a very angry and unhappy patient. Pindo described it as like a rape of my person, something disgusting, very, very bad. And so she argued that she'd suffered a violation of her right to physical integrity, which was guaranteed under the Spanish Constitution, and her right to freedom of religion, as well as the ancillary protection provisions which protected those rights within the Constitution. Here are the 2 pertinent provisions in the European Convention on Human Rights. The first in terms of respect for private and family matters, the next in relation to freedom of religion. So it was those aspects that went before the Grand Chamber ultimately. The Grand Chamber said, as I indicated less than 2 weeks ago, in the sphere of health care, respect for personal autonomy is a general and fundamental principle, safeguarded by the universally recognized rule of free and informed consent. And the key component of the decision was this: the legally competent patient who has been duly informed about their health condition and the available treatments, as well as the implications if no treatment is provided, has the right to freely decide whether to give consent or to withhold it. Now, Pindo knew well and truly what her illness was, or what her condition was. She understood that she may lose significant amounts of blood because that was part and parcel of the condition, and she'd made a considered, aware decision based on her religious beliefs about administration of blood transfusions. The Grand Chamber said that the interference complained of was the result of a decision-making process by the hospital and the judge who issued the orders permitting the transfusion, which did not afford sufficient respect for her autonomy, which was protected. And she wanted to exercise as an important part of the teaching of her religion. And so the court found that it followed that her right to respect for her private life had been violated, and it ordered a modest amount of money in pecuniary damages and financial damages and in costs. Interestingly, it was a unanimous decision by the Grand Chamber, which is what makes this decision so emphatic and significant. But the court was completely split in terms of whether to give her any money, with some of the judges saying, well, yes, there's been a technical infraction, and the result of that is that she's alive, and that's not a good enough reason to give her money. But a bare majority of 9 to 8 decided to give her a modest sum of money, which I think comes in somewhere around $20,000, and a bit more than that in terms of the costs, which were the result of multiple court appearances leading ultimately to the Grand Chamber. So I've taken you through a variety of court decisions. They're all landmark ones, all extremely interesting, I think, in their own right. Starting in South Africa, and then with applications of the principles from the South African Constitutional Court in cognate decisions in Kenya and Uganda. The important and fascinating decision in relation to the Novartis drug in India. Then the decision by a bare majority in the United States Supreme Court, which would probably go the other way with the court constituted as it is now, in relation to the impact of overcrowding on the right to health of prisoners. The courageous decision of Justice Moraes in relation to transparency of health data, and finally the decision of the European Court of Human Rights in relation to autonomy of decision-making from persons in a position to express their wishes and have their dignity protected. Each one is added to what is a growing corpus of international law in relation to health rights. The decisions, each one of them, were hard and heavily contested by government. Each one has articulated fundamental principles giving primacy to life and access to available and suitable quality health care in a variety of contexts: HIV patients, maternal and infant well-being, even the rights of prisoners. And so what we've seen over the last 22 years is this growth of a very significant, if you like, therapeutic jurisprudence, case law growing by judges' decisions, acknowledging and identifying the fundamental importance of the right to the highest attainable standard of health and applying that in practical scenarios across different countries. I hope you've found your global tour of interest, and I'm happy to answer any thoughts that you have arising from your Cook's tour of health law globally.
Thank you very much, Ian. That was fantastic. An amazing world tour in a short period of time. And I know there are some really provocative questions in the chat, which I might try to quickly relay. I can see at least two that I might try to very quickly relay. The first is a couple of questions from John Southland. John says, great presentation. How should we balance the state's obligations under ICESCR with global sustainability? For example, highest attainable might suggest that Australia should ensure maximum availability of vaccines for its population, regardless of the implications for other countries. The second example he gives is Australia's encouragement and support of foreign trained medical staff in region Australia, which would contribute to the highest attainable standard of health for us, but probably decreases standards in other countries. So provocative questions. Keen to hear your thoughts.
Yeah, at the heart of that trio of decisions in Africa was the recognition that there's some variable standard of healthcare in different countries, and I've just spent much of my last 2.5 years in the Northern Territory doing cases there to do with Indigenous deaths in one form or another, particularly in a domestic violence context. And it's so apparent that there's this huge discrepancy in availability and uptake of healthcare services in parts of our first world country. What these provisions internationally provide for is that what can be done in any given country at any given time must be done in order to provide that which is feasible to persons who require health care. it's often not what they should receive, and what it often doesn't meet that which could be provided. And Northern Territory in this country is an egregious example, where the discrepancy between what you receive in Katherine or Alice Springs as against what you get in Sydney or Melbourne is embarrassing. So these decisions have a modest impact. They result in the potential for national embarrassment from entities such as the International Court of Human Rights. But they're part of a bigger mix, really, of problematic issues that arise from inequity of access to medications, to services, and to fundamental care. And you'd think that in a country such as ours, those kinds of inequities wouldn't exist. But just as they do for prisoners in the United States, so too do they in parts of our country as well. I don't think that's a full answer to your question, but it's perhaps a start.